Good evening, everybody. Though we have the habit to say hello to our guests normally in their mother tongue, for this time I will... Why are you laughing? I don't understand. And it's just in order not to blame you too much that I take a distance to that procedure. But I first wanted to say hello and welcome for this talk about a very interesting topic, the German-Chinese rule of law dialogue. There is a dialogue, you will tell us what kind of dialogue, and that there are effects and even an outlook for the future. The rule of law question is something that's central for legal thinking. Rule of law in Germany, in France, in Germany as Rechtsstaat, and even sometimes as Rechtschreibstaat, as Josef Isensee said, is a very strong concept. Rule of law is a little bit smoother perhaps, but also related to procedural questions. The French idea of état de droit is something else to my understanding. So even the concept of the rule of law is not the same in different legal cultures. So what does it mean to try to make a legal transplant traveling around the world and just coming from Germany, in a German-Chinese dialogue where the idea of Rechtsstaat had been completely contaminated in the 30s. You really must read this kind and this way of interpreting what the Rechtsstaat of the Third Reich had been. Of course, it had the Führer to be behind and so forth. It is a complete construction of Rechtsstaat that was related to this authoritarian and horrible regime. In the name of Rechtsstaat and in the name of folk, the German folk, the Deutsche Volk, there had been procedures, there had been violation of fundamental human rights. So we are bringing the idea of Rechtsstaat to China. That's an interesting story on first hand. But you will explain to us. And after the war, in any case, there had been other discussions, and in the 20s as well. And perhaps there might be even some pride in the German tradition that Rechtsstaat was linked to the implementation of the Verwaltungsgerichtsbarkeit in the 19th century. That's the origin of the Rechtsstaat idea in Germany. As far as I see, there might be a lot of protestations against this interpretation. Who else then would be able to do that? Talk. You are not only a professor in civil law at Tongji University at Shanghai since 2003. You hold in surplus the ThyssenKrupp AG Foundation Chair for Private Economic Law at the Chinese-German College for Postgraduate Studies. That's a long title. It's about 2 lines. And not everybody has a title that goes around 2 lines. And in addition, you held a Humboldt Research Scholarship at the Humboldt University of Berlin and so forth. But since 2012, July, exactly, you are a fellow at the Käte Hamburger Center for Advanced Study Law as Culture. And we are very glad that you are with us and discussing and very often questioning our way to raise questions from a very different perspective, but a perspective that is not so different that the difference could no longer be discussed, because you are a translator of Thomas Reiser's Lehrbuch der Rechtssoziologie. That means you are not only a student, a scholar in legal thought as such, but also in the sociology of law. And that is interesting in the Chinese context. And that's why we talked a lot about the possibility of making perhaps one day a small booklet about legal sociology in China, and how different streams of legal cultures might be grasped through the lens of the law as culture question. an interesting project. One cannot say that your project of today would be more modest. That is not true. If you have a look into the long list of the German-Chinese dialogue that the Bundesministerium der Justiz has published, it is really incredible. The Rechtsstaatsdialog with China from 2003 to 2014 is really impressive. And you will tell us about this dialogue, and you will tell us also about some effects and perhaps also about an outlook. Welcome at our center once again. It is the last talk you will do this year. We come at the end of the year, but next year you will be back, and then we can continue the debate. So whenever there is a question that we could not resolve this evening, there'll be another occasion to do that. So first, thank you very much for coming and being with us and discussing and sharing knowledge with us, sharing a knowledge that comes from another part of the world that plays more and more the central role in the world. We have to recognize it. You're always very modest from China, I know, but we know what it means. Thank you very much for coming and being with us.
Professor Gebhardt, I must also thank you. Thank you very much that you invited me to come here to stay with you for 6 months. It's the time of course is flying very quickly. It's almost the end. Yeah, I will go back at the 21st of December. But these 6 months is really a very pleasure time for me. I enjoyed my staying here. I enjoyed my research here. I enjoy stay with you and the discussion with you together. As you said, the rule of law dialogue have already taken place more than 12 years. In German, there was many publications. I got these books from the Federal Justice Ministeriums. I got also materials from the Käte office in Beijing. So of course, I have not have enough time to read all the research, all the books, because if I research all the books and compare it with the Chinese laws in China, I think I need much more time. It's also very interesting to talk about this topic because, especially during these days. Because maybe all of you know, one Chinese author, Mo Ye, won the Nobel Prize of Literature. He also delivered his speech in Norwegian, but I read in the newspaper, in the internet, there was a lot of critics on Mr. Ma Ye, because many authors in China, not many, some authors in China or out of China criticize the speech of Ma Ye, because Ma Ye didn't answer the question of the journalist, reporter, what is his opinion about Liu Xiaobo. Liu Xiaobo was also one of Chinese academic who is now still in prison of China, because he tried to wrote some articles or want to try to reform Chinese political systems. Mo Ye refused to answer. He had answered this question, make some comments before, but this time in New York he didn't answer this question directly. I think the right of free speech is also one of the important contents of the rule of law state. So, of course, as you said, my presentation is the last presentation, so I'm also very happy. Okay. I will try to make my presentation about the German-Chinese rule of law state dialogue effects and outlook. I will. My presentation it consists of 7 tiles. Originally, one tile is what is the German-Chinese rule of law state dialogue. Second is why do I choose to talk about this topic. The third is the background of the dialogue and its aims. The fourth is form of the dialogue. And fifth is effects of the dialogue. And the sixth is the social and the cultural reason for the failure to realize the aim of the rule of law state dialogue. The last time is a suggestion, but I haven't finished it because I must spend more time to think about the suggestions. First, I will talk about what is the dialogue, German-Chinese rule of law state dialogue. I think most of you maybe this is the first time you heard this concept. This dialogue was started with suggestion of German Chancellor Gerhard Schröder and the Chinese Prime Minister Zhu Rongji. And with this suggestion, German Minister of the Justice Ministry, Miss Käte Dorbe-Gemelin, and the Chinese chief of the legal office of Chinese State Council signed the German-Chinese agreement on exchange and cooperation in the fields of law in 2000. On this basis, China and Germany signed the first 2-year program on implementation of the Chinese-German agreement on exchange and cooperation in the legal fields. In 2001, until now, 4 2-year programs were subscribed. And in November 2010, signed both countries the first 3 years program instead of the original 2-year program. So the dialogue is a program organized by both countries or both governments. Then what is this program, or what is dialogue? It's a kind of roof under which all kinds of activities of legal consulting projects, exchange projects, translating projects are included. They include all kinds of governmental and non-governmental legal cooperation initiatives. Among the governmental initiatives, for example, the annual official 2-day symposia, which took place alternatively in China and Germany, and the consulting activity for Chinese legislature by Käte, and German-Chinese dialogue on the question of human rights by foreign ministers and the foreign ministry of both countries. The most important non-governmental initiatives in this sense are the various conference and the consulting activities organized by different political foundations such as Friedrich Ebert Foundation, Konrad Adenauer Foundation, as well as by various university law schools and the research institutes and the translation projects of DAAD with their Chinese partners. In one word, dialogue is the name of all kinds of cooperation in the fields of law between the two countries. Then I come to the second topic. Why do I choose to talk about this topic? Until now, more than 12 years have gone. During these 12 years, dialogue have taken place in many different forms. A series of conferences were held, consulting projects for Chinese legislations and the translations were carried out. But comments on the dialogue are different. There are at least 2 different opinions about it. Politicians of both countries assessed this dialogue very highly. For example, Mr. Cao Kantai, he is the chief of the Chinese legal office of Chinese State Council. He stressed the dialogue created a good precedent for two countries with different culture and different social systems to discuss equally and friendly about the questions of rule of law state. An ex-minister of Federal Justice Ministry, Ms. Cypers, said also, not only close economic cooperation connects Germany and China together, but both countries are also closing to each other in the fields of law and politics. The dialogue can help us to reach this aim. But the public opinion in Germany are not very positive. At least since 2001, the dialogue is criticized very sharply. For example, some political and scholars in Germany said the dialogue were used as a fake leaf by both parties, so that both Chinese and the German government need not to mention the question of human rights. The real meaning behind such debate is it worth to continue the dialogue in the future? Because Germany invests not only a lot of money, but also much human resources in it. So I think this topic is very important. Besides, I have myself also participated in the dialogue. I personally interested in the effect on the future of the dialogue. So I have paid my attention to this topic. Of course, before I go further with other topics, I must first clear up some backgrounds and aims and the forms, because these are the basis for the further discussions. Now I come to the third part, the background of the dialogue and its aims. First, the background. Everybody knows since a long time China has been one important economic partner of Germany. German companies have a lot of investment in China, but they thought the legal security in China is not very satisfactory. They felt that his interests in China are not protected very well. In order to improve the legal security in China and give German investment in China a better protection, German government or the politicians considered to start a program of dialogue in the 19th years of last century. Since 1979, Chinese government have been trying to develop a legal system, a rule of law state with Chinese characteristics. In order to realize this goal, China also needs a lot of new laws. Both Germany and China belongs to the continental legal system, and German law has traditionally a big influence in China at the end of the Qing dynasty and in the Ming, in the Republic of China. Because Germany is not a purely capitalist country, but one with strong socialism element, and because Germany has a perfect legal system with strong socialist element, so it is very logical for both sides to sign agreement above in 2000, because Germany has a lot of experience in this area, and which are very useful for China. I think we can also find such considerations in the aim of the dialogue. As for the aim of the dialogue, both in Germany as in China, there was a lot of discussions, but I think I can find three of them which are shared by both German side and Chinese side. The first, the dialogue should be used as a platform for better communication and a better understanding between two countries. The second is that the situations of human rights protection in China should be improved through the dialogue. The third, the dialogue should be help to China to become a rule of law state. We can find such indications not only in the literature of both countries, but also in the preamble of the official agreement about the dialogue. If you are interested, the agreement you can find on the internet. You can read it. Then I come to the 4 parts of my presentation. The form of the dialogue, because I think form is important because it can influence of the goals or the aims of the dialogue can be realized. A close relation between the aim and the way a way to taken to achieve the aims always exist between them. After we talk about aims, so we should find out the ways or the forms of the dialogue. The forms of the dialogue are very manifold. In the last 12 years, different projects within framework of the law of law dialogue have been carried out in many different forms, but most important of them are the following. First form, annual conference. Dialogue. The annual conference is one of the most important form. It takes place once a year, alternatively in China and German. The topics are fixed by German Justice Ministry and the Chinese Legal Office of the State Council after they change their opinions and reach a consensus. Until now, 12 such annual conferences have been taking place. The topics of the conferences carry a very broad areas. For example, administration law, law of state authorization procedures, the role of state in economic lives, the internet law, the protect of copyright, trademark, and personality right in internet, disclosure of governmental and administrative information. Yeah, I will not read all of them. And participators of both countries discuss about these topics and exchange their opinions. But in Cannes, I believe the conference have deals with the questions how China should stipulate a new law in the discussed fields, or how to revise an existing law. Besides this annual conference, there was also a kind of small conference which was organized by Käte. Käte had supported the legal transaction of China on behalf of German Ministry of Economic Cooperation and Development since 1994. If Chinese government or the National Congress plans to make a new law, Käte will ask German experts to express their opinions how it should be made. At the first, the consulting service of the Käte is limited to the fields of labor law, social security law. Then it also covers areas of economic law, civil law, administration law, company law, property law, budget law, tax law, and so on. Besides, Käte also organized many training programs for Chinese government and the Justice Ministry, so that Chinese officials and judges can know how to implement the regulations. The second form of the dialogue is the human rights dialogue. The human rights dialogue between Germany and China is one of the important part of the dialogue. It is organized. It is originated from the suggestion of Gerhard Schröder and Mr. Zhu Rongji in 1999. German Foreign Ministry and the Chinese Ministry of Foreign Affairs are partners of this dialogue. It takes place usually one time every year. The 10th conference is held in this year in Wiesbaden in Germany. Most of the participators are politicians and diplomat officials, both countries. They also discuss questions of judicial procedure, of criminal law, human rights protection, discrimination of minority, international cooperation in the fields of human rights protection. The third form of the dialogue is the cooperation project within the universities of both countries. Between the different universities between two countries, there are many cooperation projects in the fields of law. They also constitute parts of the dialogue. Three of them are most of important. The first is the German-Chinese Institute of Law, which is set up and carried on by Nanjing University and the Göttingen University together in 1988 and 1981. It still goes on. The second institute is the German-Chinese College of Law at the Chinese University of Political Science and Law, which is set up in 2002. This institute had 6 partners in Germany. Among them are Freiburg University, Munich University, Köln University, and Hamburg, Frankfurt University. The third institute is the Department of Economic Law of CDHK, Tongji University, that's my university, which began in 2003 and cooperated with Hamburger University and the Konstanz University, also in the fields of training master students, but officially set up in 2007. I was one of the gründer of this department. Now, Tongji University is planning to set up a German-Chinese Institute of Economic Law instead of the Department of Economic Law of CDHK, with 2 partners in Germany. The main task of these institutes is to educate qualified postgraduate students in the fields of law with their partners in Germany. If the students fulfill the conditions of both universities, they got 2 master degree, one from Germany, one from China. It should be mentioned that the 3 institutions have also organized many legal conferences in the framework of dialogue. For example, the Department of Economic Law of CDHK had organized a series of legal conferences with Hamburger University, with Konrad Adenauer Foundation, Siemens AG from 2002. A wide range of topics were discussed during the conference. For example, implementation of public tasks through the private companies, corporate governance in international perspectives, and so on. The fourth form is the translation project. In the past years, more than dozens of representative German legal academic books have been translated from German into Chinese and published in China. The translation project of DAAD is one of the most important and the most influential of all. Until 2012, through this project, 22 representative German legal academics have been translated from German into Chinese. 27 of them have already published in China, and 5 of them are still in printing. Of course, to mention is also one small translation project which are financed by Konrad Adenauer Foundation. Yeah, I'm responsible for this project. Professor Gebhardt had already mentioned it. I had translated 2 books of Thomas Reiser into Chinese and published in China. And my colleague, Mr. Zhang Qiming, had also translated 2 books. I think both are from the Humboldt Bonn University. One is the International Economic Law from Professor Hedegan. It's also published in China. And another is the economic analysis of the civil law from Professor Schaefer. I think he's also professor of Bonn University or Hamburg University. Okay. Of course, there was other forms. For example, the office. German trade patent office, the Munich Max-Planck Institute of Intellectual Property, have also cooperated with Chinese experts at the time when Chinese patent trademark office was set up in the 18th or the 19th years of last century. Alexander Humboldt Foundation, Bucetis Law School, Federal Supreme Court had also many different projects in the framework of the dialogue. Then I come to the fifth part, the effects of the dialogue. In order to find out the real effects objectively, I will analyze the most important form of the dialogue and then analyze them separatively. Of course, the first form, the most form is the conference. But conference. There were many conferences, more than altogether more than 100 conferences. There was much more than 10 books have already published, but not published. That's a book in not published book. It's a book. Yeah. If I have analyzed the I analyzed the contents of the conference, what pitching was discussed in the conference, and what kind of suggestions German experts had made during the conference, and I compared the Chinese law, the concerned law, and found if there were some comments. Of course, maybe it's not enough to prove the Chinese enacted law are influenced by German the dialogue, but I can only support my opinion on such in this proof. I had only analyzed the two law, but I think we don't have enough time. I only give one example. That's the sixth conference in the framework of this dialogue. The topic of the conference is disclosure of governments and administrative information in 2005. And in 2007, Chinese government, the State Council, had enacted the Chinese Government Information Disclosure Regulation. Then I first discuss. I want to introduce what kind of question was discussed during the sixth conference. During the conference, Chinese sides pay special attention to the following four questions. First question is, how can a law balance the interest of people to get more information and the interest of the state to keep a secret in favor of state security or in favor of a third person? The second question is, how can a law deal with the relationship between an active disclosure and disclosure on the basis of application? The third question, should the disclosure be free of charge? The fourth, how can the right of the applicant of information be enough protected? German experts give detailed explanations to these questions according to German information freedom law, Informationsfreiheitsgesetz. To the first question, German expert gave the following answers. The public interest, such as military security, state security, should be protected. If someone asks for disclosure of such information, the applicant should be refused. Besides, if the concerned information belongs to the secrets of a company of any third persons, the disclosure will injure his interest, then it can only be disclosed if the third person agrees with it. To the second question, German expert gave the following answer. According to the German law, German administrative department should disclose the information actively, but at the same time, he should disclose it because of the application from a third person, from a citizen. The answer to the third question is also very clear. In most of the cases, disclosure of information must be free of any charge. But in some complicated cases, fees can be charged, but they cannot exceed their costs. As to the question of protect the interest of applicant, German experts mentioned two different ways in German law. The one is the state must fix a period of time during which the applicated information must be disclosed. According to German law, the period in the usual case is 1 month. In complicated case, the period is 2 months. The second is if the applicant is refused or not handled within the fixed period of time, the applicant can sue against the government department at a court. Then we look at upon the contents of the Chinese law, what I just mentioned. To the first question, Article 14 under 21 deal with this question. It's exactly almost the same as what German experts suggested. If the information consists with state security in the meaning of state secrecy law, the application must be refused. And if the administrative department believes that information which is applied to disclose belongs to secrecy of one company or any third persons, and the disclosure will injure his interest, then it can only be disclosed if the third person agrees with it. Otherwise, the application must be refused. And to the third question, Chinese law also confirmed the two ways. The one is the administrative department should disclose information actively without applications. And if there is a new information or disclosed information is changed, the government must disclose it within 20 days after the form of new information or change of it. At the same time, people, citizens, legal persons, or other organizations have right to ask the government to disclose information. The third, the charge of fee. The government can only charge fees which cover the cost of search, copying on the post. Besides, they cannot charge any other fees. They cannot also entrust a third person to disclose information on basis of paid service. If an applicant is really difficult, he cannot pay the fee. He can be also exempted from it, or pay only reduce the price. The protection of the applicant. Chinese law also confirmed the two ways of protection. The first, Chinese law fixed the period of time to disclosure. In the usual case, the government must disclose the information at the moment when he received application. If it is not possible, he must disclose it within 15 days after received application. If it is still impossible, he can ask for extension, which cannot last more than another 15 days. If the applied information concerns the interest of the third person, the time is not which is used to ask for permission from him should not be calculated into the period above. To the last question, if the applicant believes the government harms his legal interest from the law, I mentioned it above. For example, the government refused to disclose the information, or does not disclose it within the time fixed by law, or the disclosed information does not conform with his requirement, he can sue to the court. the court must hear the case. In reality, this law is in the last years very often in the practice used. I know many lawyers use this law and ask for information from the government. It's also very successful. Because another example I will not because it's too long. From this example, we can say almost all the suggestions of the German expert are accepted. We can find the same context in the Chinese law. That's the conference, that's the legal consulting. Then I come to the second form, the human rights dialogue and their effects. Just as I mentioned, another important form of the dialogue is the human rights, or another topic is the human rights. Both sides had organized 10 conferences, especially on this topic. Then, is this dialogue also so successful as the legal consulting? Or are they great improvement in this area? Of course, it's also very difficult for me to describe the links between the dialogue and the situation of human rights in China, because the real picture of human rights protection in China is really very many-sided. First side is stagnation without much development. It seems that the dialogue haven't improved the situation of human rights protection in China very much, because some things stayed without big change. For example, insisting on official understanding of the concept of human rights. Everybody knows that Chinese official opinion about the concept of human rights is different from that of German or other countries. According to Chinese official, human rights consists of the right of living and development, of free speech, of practice of religion. But the right of living and the development are the most primary concerns than others. While in Western countries, much more attentions are paid to the political rights, such as freedom of speech, freedom of press, or freedom of religion. To mention is that not only Chinese government holds the opinion above, this opinion is also shared by many Chinese scholars of human rights. This shows that during the past 10 years, this official opinion haven't been changed. The second example is the case of limited human rights. There are still cases on which the freedom of citizens of individual persons are restricted. One of the famous examples is Ai Weiwei. I think most of Germans know him. According to the report of Western media, he was put into house arrest because he was involved into the investigation of the causes of the collapse of some public schools during the earthquake in Sichuan province in 2009. He believes that the corruption of the official lead to the bad quality of the school buildings and is responsible for the collapse. According to Chinese media, he was put into house arrest because Ai Weiwei had not paid the tax according to Chinese law. He has tax evasion. In the last 10 years, we can see such cases happen occasionally. And this shows also, or this indicates that great change haven't taken place in this area. But I want to also say the other side of the human rights. The other side means there was great improvement in these fields. in spite of the example I mentioned above. Why? First, concept of human rights are already widely known in China. The terminology of human rights doesn't come from Chinese culture and was imported into China. 20 years before, only a few Chinese know the term, but it's not. But now it's very popular. You can read it in the newspaper. You can hear it in radio. Besides, a lot of Chinese understand the meaning of this term very well because there are more than 100 of research institutes of human rights in whole China. Thousands of Chinese scholars who have specialized in this area. Some of them may share the opinion of the Chinese government, but they also know the concept, the opinion of the Western countries. To mention is the human rights is one of the selective courses at the university. During the course, not only the official opinion of Chinese government, but also that of Western countries are taught and discussed. So Chinese students or the people can make his own judgment. The second example is academic freedom. It is well-known fact that the scholars in China have no academic freedom in the 17 or 18 years of last century. One could be put into prison because he criticized the party leader in China or made comments on the policy of Chinese government at this time. But things are totally different now. Chinese scholars can use bad examples such as corruption, environmental pollution to criticize the policy of government. Such courses or lectures are also usually very welcome by the students. Besides, scholars can write articles to criticize or make comments on the phenomenon of Chinese society. Some of the criticisms are so sharp and intense that you cannot imagine that such books or articles can be published in China. In fact, there was almost no limit for academic discussion. We can discuss how to reform the Chinese justice, judicial reform, if a constitution court can be established in China. Freedom of speech. It is also not very fair or very objective to say that there is no freedom of speech because of the case of AAW or something, the cases like that. Now, Chinese have much more freedom of speech than 30 years before. Of course, just as mentioned, the Chinese author Mo Ye, Nobel Prize winner, was criticized nowadays. But I also want to take one of his books as an example. One of the books, the title of the book is the Garlic Ballads. He told a real story. Of course, he said this story happened not in China. In the Paradise. In the Paradise, there was a communist society. But he told a story of the Chinese farmer. The local government encouraged the farmer in the country to plant garlic. And most of the farmers in this country had planted the garlic correspondingly, and the garlic was cropped very well. But because there was too much garlic on the market, the farmers could not sell them. Most of the harvest became wither or the rot in the fields. But the local government official did not even try to help the farmer to sell the garlic. On the contrary, the government did everything to make the selling more difficult. For example, they're getting road taxes and so on. In the end, the farmers are very angry. Are so angry they march into the city and burn down the government building. It's in my personal opinion, it's really a very sharp critic on the Chinese government. You can also find this other critics in his other novels. For example, in his novel Fog, he criticized the strict enforcement of family planning policy. But these books are also published in China. He is a well-known author in China. Of course, he is also a fisher. That's in China it's almost the same as non-governmental organization. Yeah. And fourth example, the free movement of persons. Before 1980, Chinese had no right to move freely. If we wanted to travel to another city, we should get a letter of permission from the local government, which prove why we travel to the other city, how long we could stay there. Now, we don't need such letter of permission anymore. Besides, even during a quite long time after the beginning of economic reform in 1979, Chinese had no right to choose city where he lives and works. Now, if you can get a job in any city, you can work there and live there. I can mention quite a lot of examples to prove this. So summarize. I will not go further. I will summarize. What we can say that although the situation of human rights protection in China is problematic, and many things should be done in order to make further improvement in these areas, but it is also a fact that human rights are much more protected than before at any time in the Chinese history. So we cannot use the limited number of cases where the human rights of specific person is limited to deny the great improvement. Then I come to the third form of the dialogue, the cooperation with university. I would say this form of cooperation dialogue is very successful. I just mentioned three institutions between Chinese and German university. Until now, from these three institutions, about 200 Chinese students have finished his postgraduate study in German and China and obtained 2 LLM certificates. Besides, 1/3 of them have got a Juris Doctor title from university in German or are still working hard for these titles. But most important is that not only the concerned students themselves have surely a better understanding of the meaning of the rule of law state, I think they could influence hundreds of thousands of other Chinese when they return to China and work as a teacher at the university or judge at the Chinese court. Of course, if they translate German legal books from German into Chinese, publish them in China, they will influence much more people. Of course, such cooperation can also influence the Chinese legal system directly. One example is the Mr. Tian Lipu. He is now the president of Chinese Patent Law Office. He made his further education at the European Patent Office, German Patent Office, Federal Patent Court at the Max Planck Institute in Munich between 1980 and 1929. And because his influence, Chinese patent law is almost a copy of the German patent law. And then I come to the fourth form of the dialogue, the translation. I think the translation projects are also very successful because if the Chinese translation is very good, not only Chinese law professor, but also law students read these books. For example, the law of the capital company, the introduction of sociology of law of Thomas Reiser, and now standard reference book in most of Chinese law schools. about 10,000, 100,000. 10,000 exemplars of law of capital and 6,000 introduction of sociology of law have already sold out in China. Besides, even the Chinese judges also read such books. If they face complicated cases and they cannot reach a reasonable and lawful decision according to Chinese law, they read such books and try to find the approach for his decisions. So summarized, what are the effect of the dialogue? It depends on what kind of aim the dialogue try to reach. If the dialogue is only a platform between both countries, I think these aims are already reached. If the aim of the dialogue intends to improve the human rights protection in China, I think, although not all the aims are already reached, but in China there was also great improvement in this area. As for the last aim, the rule of law state, I think this aim is also not totally realized, but part of them is already realized. For example, legislature. Legislature is of course in part of the rule of law states. Besides, enforcement of law also make progress during the past years. Summarize, we can say that of course important is the rule of law state, because if China is a rule of law state, human rights will be better protected. But this goal, these aims, seem to me, from the fact what I introduced is not totally realized. And then I try to analyze the reason. I personally believe that both German sides and the Chinese side are responsible for this not very satisfactory result. First, the German sides. I think to turn China into a rule of law state, this aim is too ambitious. Rule of law state is not only concept, an idea, or a specific law, but a complete legal system, a political system, an administrative system, a judicial system. It is not very easy for a reasonable person with normal intelligence to understand what the rule of law state is, what it consists of, how it works. Only when the person spent years on research on it, then he can understand it. But it takes much longer time to build such a legal system in a country. Germany is a very small country with much less population. How long had Germany needed to turn himself into the modern rule of law state? 12 years? 20 years? You know this answer better than I. China is a huge country with more than 1.3 billion population. It is much more complicated to build a rule of law state in China. 12 years is of course not enough. No suitable forms. As I mentioned above, the rule of law state is not only concept, an idea or specific law, but it's a complete social system. It's not very easy for ordinary people to understand it. Even through the form or through of the dialogue. The more often used form of the dialogue is the conference. which usually last 2 days. In 2 days, nobody can understand what rule of law state. Besides, the topic of all conferences are not planned according to the contents and logic of rule of law. So even if a same person have taken part in all the conferences in the last 12 years, he cannot also understand how the rule of law state works. Not to mention that this is not the case because usually different persons, also from the Chinese side, participate in different conferences. Cooperation between universities and the translations. Of course, as I said, these are very successful, but we cannot waiting that through the cooperation between university we can turn China into a rule of law state, because most of the observant graduate students are still very young. Most of them are still students. They have no influence in Chinese political social life at the moment. Yeah, that's the reason from the German side. Then in the following I will mention the reason on the Chinese side. There was also, on Chinese side, there was also many reasons. The first or the most important reasons is there was no political will. Dialogue is something like marriage. Both sides must not only appreciate each other, love each other, they must also have some common ideas. Then they can come together. Or dialogue is something like a business deal. A contract that can only be signed by both parties if they have common wills. The aim of the rule of law state can only be reached if there is common will of both China and the German. Although the term of the rule of law is mentioned in the preamble of the agreement, but it is pity that it is not the common will of both countries, because China and the German had his own understanding of his term. Yet the official attitude of Chinese government is that Chinese political system should be, although further democratized, but China doesn't need the democratic system in Western countries. China wants to develop a new art of democratic system with Chinese characteristics. I'm not expert of political science, but if I'm not mistaken, rule of law state, rule of law state is one important and indispensable part of the democratic political systems. If Chinese government doesn't need the democratic political system from West countries, they also doesn't need the system of rule of law state in the meaning of West countries. I agree totally with the opinion of German expert of dialogue, Professor Katja Levy. She believes that China has already made good developed the legal system, but China tries to go his own way during the procedure of building its legal systems. Yeah, that's Chinese legal system, rule of law state with Chinese characteristics. So if there's no common will, so of course these aims cannot be reached. The second reason, traditional Chinese cultural or the social background. Just as I mentioned before, China had already a very good developed legal system. Chinese government must also use his administrative right according to this law. Then we are facing a very difficult question: why there are still such cases where the right of free speech or even personal liberty are limited? And this happened every now and then again, because not all these limitations are in line with of Chinese law. this question is also not very easy to answer. I personally believe that both modern legal system and the traditional Chinese culture have played here an important role. Modern legal system, personal account for instability. Everybody knows that keeping of social stability is one of the central tasks of Chinese government. Every official of the Chinese local government is responsible for the stability of his specific area. If something happened in this area which could lead to social disability, the official will be made liable for it. Therefore, he can lose his position or to be moved to a low position. This is one regulation of the modern legal system. The original intent of such a regulation is not very bad, or it's very good. They should, because they try to motivate or to force the local official to solve all the social problems with legal methods which happen in his area. Of course, this is also one of the important tasks of the local government, but such regulations are also unbelievable side effects. In order to protect himself from such negative influences, the first reaction of the local official is try to withhold the truth. If something happened in his area which could attract public attention, he usually take two different measures without analyzing why such thing happened, if the requests of the concerned person are reasonable and lawful. One of them is to pay money to the concerned person so that the persons can keep silent. Another is to limit the personal liability. Both measures are not legal according to Chinese law. Besides, they have also bad effect. The first one is kind of encouragement for unlawful and unreasonable requirements. People will thought the government can be blackmailed if they try to let push comes to the shove. The second one can only intensify or sharpen the contradiction, not to mention solve the problems. This is one of the reasons why the social conflict in the last year are much more intensified than before. Although Chinese government have been trying to keep social stability since years. The second part is the special traditional culture. In Western countries, yes, the first point in the area of traditional Chinese culture is the mixed national affair with family affair together. In the West country is only country. Of Chinese country, if I say country of Chinese, there was two words, 国家. 国 is country, 家 is family. Yeah, it means from the name of the country in Chinese, it also indication that country there was a close link between country and the family. In the traditional Chinese culture, country was really compared as family. In one of the four classics of Confucianism, this book, the classic name of this class has the university. There was one famous maxim of Chinese: 正心修身齐家治国平天下. In English, to rule his state well, he have to govern his family well. He has first to govern his family well. To govern his family well, he had first to cultivate himself. To cultivate himself, he had first to set his heart right. From this famous maxim, we can see that the ability to govern a family is compared with the ability to rule a country in traditional Chinese culture. This comparison between country and a family has also influence on Chinese legal culture. Behind it lie the rule of traditional Chinese social order of Confucianism and concerned punishment in case of violating such rules. That is to say, the son must be absolutely filial towards his father, the official and the people must be absolutely loyal to the emperor, and the people must be always filiate to the official. Because the official ruled area on behalf of the emperor. So if somebody was not filial, not loyal, it was one of the worst crimes in traditional Chinese culture. The concerned person must be punished. Even in Chinese culture today, country is also compared as a big family, while the individual family is regarded as a little family. Affiliated piety and loyalty are still important part of Chinese culture. Although there are modern laws in China, but I don't believe that all the officials have strong legal consciousness. It is possible some of them still believe that they are officials in the traditional meaning, and the people must affiliate to them. If so, then it is not strange the case which happened in China occasionally, where the personal liberty or right of speech is limited. Then the second traditional Chinese culture, there was one famous traditional Chinese cultural bit. In English, it's settlement of family quarrels behind closed doors. I think all the Chinese know this important Chinese culture bit of Chinese 家丑不可外扬. In English, it means family quarrels must be settled behind the doors, or family scandals cannot be spread outside the family. It is said that this idiom comes from one of the four famous classics novel of Chinese literature, Journey to the West. I mentioned the novel last time. It was a novel of Song Dynasty. The author lived, I think, 1500 in the year. But I personally not believe it. I'm convinced that this bit has something with kinship family to do. Until Qing Dynasty, kinship family was one of the most basic and powerful social organization among Chinese society, because such family owns not only many properties but also laws. He can even enforce his own kinship laws. Besides, such family are really very huge. In Tang Dynasty, there was already big kinship family with 9 generations living together. This is also not the biggest one. There was even a kinship family with 13 generations, which had altogether 700 members living under the same roof. The sheikh, the boss, yeah, the chef, the sheikh of the family. Well, of course, for him, it is very happy to see so many persons live together around him. But I don't believe everybody within the family are very happy. There are always a lot of problems, such as a private vendetta or not tolerable love affairs among the members. Such scandals must be settled within the family. If one of the member of the family told such things to somebody outside the family, he not only violated against the kinship law, and the concerned person must be punished. Otherwise, it would damage the good reputation of the family. I think these things happen also even nowadays. Can be compared with such cases. For example, if somebody didn't agree with the plan of relocation of his house, or the immigrant worker didn't get his wages, it is not very easy to settle such conflicts immediately and lawfully. But the local officials thought that such event could lead to social disability, and if such things or the event were told outside his area, the administrative ability of his or the local official will be put into question. So the local official would try to use all possible methods to prevent the news to spread outside. They don't care if the methods are legally or not. There was another traditional Chinese bit which has the closer relationship which I mentioned above. Of Chinese is called 个人自扫门前雪，莫管他人误赏伤. In English, it means each one sweeps the snow from his own doorsteps and doesn't bother about the frost on the neighbor's roofs. Or can also translate mind only his own business and not to meddle in other people's affairs. It is said that this bit comes from one book. The name of the book is Documents about the Kinds of Social Events, written by Mr. Chen in Song Dynasty. But I also believe that this bit had also close relationship with kinship family. As I told that every kinship family had his own secret scandals, which may be not lawful, also not moral. So the family always tried to keep this scandal within his family on the one side, but on the other side, he tried to prevent any interference from his neighbors. In the fact, the second bit can also help the kinship family to solve his conflict after the closing door. Because if nobody say anything about what he has done to his family members, then he can take any measures to settle such conflicts. This traditional Chinese culture bit had also influenced the behavior of Chinese officials mentioned above. Chinese officials were not we only concentrate on the things or the event which happened in his area. He will not intervene in the issue which happened in other area. Even the measures taken by officials in the neighbor area are illegal because it's not his business. I think that's also the reason why Chinese government also criticize the social government when they make comments on Chinese policy or the event. Summarized, from what I mentioned above, we can come to the conclusion that both Chinese sides and German sides are responsible for the failure to not realize a rule of law state in China. But the most decisive reasons of all are that China has another legal tradition as rule of law state and no strong consensus about building a rule of law state within China. Although China has a very long history, traditional Chinese law was also codified But traditional Chinese law, for example, Ming Code, is not so abstract enough. Its rules are also very rigid, and the systematic classification is also not so logically as the German law. And different body of law, such as constitution, administration law, criminal law, have not been developed in traditional China. Apart from that, the rule of Confucian as a soft law were very influential in traditional law and are also very influential in modern China. After 1949, Chinese legal systems were in chaos for a very long time because many different political movements happened one after another. Only after 1979, China began to rebuild its legal systems. Now, many Chinese people believe that rule of law state is very good for China. Only when China is turned into a rule of law state, then China will develop harmoniously and peacefully. But in China, there was still a lot of people who knew nothing about the concept of legal rule of law, but only the traditional Chinese culture or ideology or the system of communism. Besides, most of Chinese officials don't understand really how the law of state works. Under this circumstance, it's not very realistic to hope that rule of law state could be built in China within 12 years. Only most of Chinese people got not only very familiar with the concept of rule of law, but they are convinced the rule of law state is very good for the stability and the development of Chinese society. Then the realization of this goal is possible. Yeah, thank you very much.